Amendment, which is specifically aimed at states, not the national government, at states, that due process clause can be read in such a way as to encompass the guarantees of freedom of speech and press. So when we talk about liberty guaranteed against the states, we include the guarantees of freedom of speech and press. Okay? And that's what we mean by incorporation. So the court is literally taking a provision out of the Bill of Rights, bringing it down to the 14th Amendment, sticking it into the due process clause, thereby making it applicable against the Commonwealth of Pennsylvania as well as against the nation. Now in that case, and incidentally Ben Gitlow, his conviction was sustained in spite of that claim. He went into the slammer for 10 years, came out, and joined the FBI as an informant. There is hope. There is hope. Okay? Where else could you do that? Okay. Yeah, a checkered career, shall we say. A checkered career. Okay. The court starts incorporating pieces of the Bill of Rights. Starts with freedom of speech and press. The ends of the 20s into the 1930s, it incorporates the guarantee of free exercise of religion, also from the First Amendment. Guarantees the freedom of assembly in 1937. And others, and in piecemeal fashion. Now we get to an interesting turning point. There's a fellow named Palko who is found guilty of murder under state law in Connecticut, 1937. The jury comes back and votes in favor of life imprisonment for this crime. Under Connecticut state law at that time, it was possible for the prosecutor to call for another trial and ask for a more serious penalty. And the prosecutor did that. Palko was retried, same crime, same circumstances. This time, a new jury came back and gave the prosecutor what he asked for, which was the death penalty. Now, what happened to Palko? What do we call that? Double jeopardy, right? He is tried 2 times for the same crime in the same jurisdiction. Okay? Now there is a guarantee in the Bill of Rights against double jeopardy. Palko appeals to the Supreme Court of the United States and said, may it please the court, would you please incorporate the double jeopardy provision into the 14th Amendment, due process clause, so as to make it applicable against the state of Connecticut. And the court said, no, we're not going to do that. Okay, well now this puts the court in a strange position because heretofore the court had been going along saying, yes, we're going to incorporate speech, press, assembly, religion, so on. And now, all of a sudden, 1937, the court says, but we're not going to incorporate double jeopardy. So the court's now in a strange position of saying, basically, some provisions of the Bill of Rights are incorporated, others aren't. Why? Justice Cardozo writes for the court, and his explanation is this. He says, well, there are different sorts of rights in the Bill of Rights. There are 2 basic levels of rights, as he describes it. One is a very basic level. These are what he calls the fundamental rights. These are, not his language, mine, the building blocks of our society. Things like freedom of speech. These are the essentials, okay? And then he says there's another group of rights, also in that Bill of Rights, which while important, his word, are not fundamental. They're sort of second level rights. The really fundamental ones are, quote, implicit in the concept of ordered liberty, his term. But then there are these others that don't quite rise to that level, and unfortunately for Palco, double jeopardy is one of those. So we're not going to incorporate. Now, some members of the court get upset with that. Justice Black, for example, Justice Douglas, say, you know, this is a little screwy because here we are, the court of 1937, and we're reaching back historically to 1791, and we're saying, we're making the decision that some of these rights have a certain status and other rights fall below that status. Who are we to do that? We are picking and choosing. And so their theory was, you ought to incorporate the whole Bill of Rights into the 14th, or none of it, all or nothing. But don't pick and choose. Well, the court decided to pick and choose, following the Cardozo lead. What happens over time is that by the time you get to 1969, the end of Earl Warren's tenure on the court, virtually every important item from the Bill of Rights has been incorporated. But it's been done piecemeal. A case here, a case there, through time. All right? And this is what was called the honor roll theory. Appropriate. All right? Some are A-level rights, some are B-level. The A-level, the honor roll rights get incorporated, the other ones don't. But eventually, virtually all of them did get incorporated. Interestingly, in 1961, the last decision written by Earl Warren before he retired, the last one, at the end of the term, 1969, was the incorporation of double jeopardy, reversing the Palco decision. By this time, Palco was dead and had turned to dust. So it didn't help. But the principle was nice. Okay. So in this way, incorporation, this is a mechanical contrivance created by the court to expand the coverage of the Bill of Rights. That's the important thing. All right? So now every basic provision from the Bill of Rights applies to the states as well as to the nation. Okay? All right. Now, let's look at the ways in which the court has expanded the coverage in a different way. State action. Okay? This is one you have in hand. Oh, right? You have that page? State action. Let me give you a little history. Everybody have one? State action. Okay. A little bit of history. In the 1920s, the state of Texas, which was controlled completely by the Democratic Party, if you were going to be a serious politician in the state of Texas in the 1920s, you had to be a Democrat, or you were out of it. And that meant that the Democratic Party primaries were, for all intents and purposes, the election. Whoever won the primary won the general. That was in the Democratic Party. The Democratic Party in Texas in the 1920s passed a rule. Actually, the state passed a rule. The state, which was controlled by the Democrats.